welcome to the Personal Injury Law Show. This is a show that talks about everything current in the law of personal injuries and obviously of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me tonight I've got John Karantzis, an accredited specialist in workers' comp. Good evening, John.
Hi Tony, hi viewers.
And Irena Krakic, a compo lawyer in a law firm. Good evening, Irena.
Good evening, Tony. Thanks for having me.
Tonight, viewers, we're going to give you an update on South Australian law in compensation. It's very important because there's been significant changes, so stay tuned for that.
However, before we get to that, Tony, what's in the news?
The first one I want to kick off with, Irena, and I'll get you to give me a hand with this, is there seems to be a massive dropout in the number of our high school students. Anything up to 25 to 30% are dropping out before year 10. That's of alarming concern, isn't it, Irena?
It's a large concern in the community, and I think it would definitely impact jobs and employment in the future, and it's something that we definitely need to address.
I guess on the other side of the equation, Tony, is there's a lot of people are not. They don't want to go to university, Tony.
They don't want to study. They want to.
And you know what? A trade like carpentry, electrician, plumbing, that's fantastic.
It is.
And you make a stack of money.
But my concern is that a lot of these kids that are dropping out at 15 and 16, they wouldn't have the basics in mathematics, English, and I just think that, in years to come, we can't have a society that's totally, when it comes to these basic educational skills they don't have. Do you agree with that, Irena?
I do agree, and I think it's difficult when they do go into these trades, and if by chance they do get injured at work, they don't have something else to fall back on. They don't have those basic computer skills.
That's a good point, actually. Yeah, you don't think, John?
Which is the argument we have with Workcover all the time, that we've got here a employee that's worked all his life in a blue-collar, physical labouring work, and he's only done year 10. So how can he be retrained?
Exactly. That's a really good point that the article didn't pick up, Irena. All right, we'll keep moving. This is close to you and John's heart.
It is.
Credit card rip-off. What's this all about?
So it's about the Turnbull government and something that they're going to implement. So currently we're being charged anything up to about 4% surcharge on credit card payments.
So let me get this right, Irena. If you go and spend $1,000, are you saying that you're paying 4% over and above that?
That's correct. Up to about 4%.
Exactly.
John, that's
exactly.
Isn't it?
I paid a $7,000 bill yesterday, Tony, on a credit card. They charged 2.5% surcharge simply because I was using a credit card.
What's the math on that?
Exactly. It's a waste of money.
It's a lot of money, isn't it?
Yeah, it's $200-300 down the drain.
That's absolutely extraordinary.
And when it only costs that maker 0.5% for the usage of the credit card. Therefore,
what is that, the admin costs?
Exactly.
And, costs of computers and whatever.
Exactly. So really, it's a rip-off, Tony. And I'm glad the government's looking into this and hopefully changing the law next year.
Look, if you consider the amount of purchases we make on credit cards, Irena, school fees, holidays. Well, you just booked a holiday the other day, apparently. What did that cost you? That's
right. So I had a situation yesterday where I called up a particular company and I was advised that the credit card surcharge would be 1.98%, so on top of the fee, and I just thought that was ridiculous, so I just went and booked online, which didn't attract the fee. So you've got to do research before paying for these services, but the sort of biggest offenders are airline companies and restaurants.
I'm astounded because the banks don't get the fees.
No, it's the actual...
I thought they were going to the banks.
No.
So it's the operators that are getting it.
Exactly.
Oh, geez, that's a good little markup, isn't it?
Exactly.
Viewers, this is a very interesting topic. We'll come back to this in the future.
Tony, it's akin to misleading and deceptive conduct.
All right, the 12th floor plunge in New South Wales. 2 window cleaners.
Wow.
They're on the 12th floor. All of a sudden, there's a loud bang. The rope that the pulley that holds the cage together just snapped. It's insane.
Plummeting 12 stories, Tony.
That is
to the ground.
Absolutely outrageous.
I'm surprised they're still alive.
So am I. They had horrendous injuries, Irena.
That's right. They both sustained some back, leg, and internal injuries, and it's.
So they're entitled to workers' compensation entitlements in New South Wales.
Yes.
However, the common law entitlements in New South Wales are very limited, aren't they, Tony?
They are limited, but it's very important you get advice from lawyers because even though they're limited, there's always a way of getting a result. And the test is a lot harder than Victoria.
Unfortunately, the government has really restricted restricted workers entitlements.
They have. If it was in Victoria, Irena, they'd have a good claim, wouldn't they?
That's correct. Depending on how their injuries go moving forward.
Well, they look like they're going to be incapacitated for a significant time.
So yeah, they would definitely be entitled to some compensation, but unfortunately New South Wales just doesn't attract those benefits.
Yeah, they attract benefits, but not quite as good as Victoria.
Exactly.
John, I guess the big thing about these injured workers is if they've got a serious injury, which they probably have,
Oh, yes.
the payout would be pretty significant.
Oh, significant
Pain
for pain and suffering, and then for economic loss, especially in the future. If they can't work again because of severe spinal injuries, which they
And
have,
internal injuries, yeah.
it's just, you're literally compensating for the rest of their work life.
Exactly, and it's pretty big, isn't it?
Exactly.
Irena, tell us about the public servant who got compo for a stroke. On the face of it, it looks like the system was generous to him, but I believe he was entitled.
That's right, he certainly was entitled to compensation. Basically the fact he was a public servant who was performing his duties in Sydney at the time. He was originally based in Dubai, but he was sent to Sydney. It was found that his hotel room had services such as he had a computer there, he had access to administration support, and all factors leading towards him being in the course of employment. And it was his employer that induced him to be in that particular hotel room. So
he was working at the time. That's the key to the whole thing, isn't it, John?
Yes.
The fact that he was working when he had his stroke, and obviously he was travelling a bit, so he was under a bit of pressure.
Yeah.
And I guess what's the test? I mean, if it was in Victoria, it'd be a significant contributing factor. But
Exactly.
this is
It's a ComCare scheme, which is a slightly different test. But again, Tony, it's a analysis of the factual metrics
Yes.
of what's happened, and clearly, as Irena has pointed out, he is in the course of work and he's performing work even from his own hotel room.
Yes.
So
just before the stroke, he was working.
that's right.
And he intended to work just after the stroke.
That's right. He performed some duties prior to having a shower, had the stroke, and it was found that he did have an intention of working for the rest of the day.
Well, it's interesting. John, this is a very interesting case. A pizzeria owner has threatened to take a fellow who put an article on TripAdvisor to court for defamation.
yes.
Because he's said, look, I didn't get my money's worth. Tell us a bit more about it.
Yeah,
It's a very interesting case.
It's a review, Tony. It's a classic Gen Y problem in the
I
sense
don't know.
that
I wouldn't be too happy either. I mean, I was starving.
is in the sense that they've gone to this pizza restaurant, paid $50 worth of food, and apparently the food was
There was not much of it.
Not much of it. Pretty lousy. The allegation is, and this law graduate Julian Tully has wrote a damning review on TripAdvisor about this pizza restaurant, and the pizza owner is not impressed.
Livid. Irena, you know what's interesting? Mr. Tully said that for $40 a head I could have bought a pizza at half the price and filled myself up.
It sounds like they certainly didn't get their money's worth, but that's right. The review was on Facebook as well as TripAdvisor. So I wouldn't be happy as a restaurant owner to have something negatively written about me. But I think the issue here is what actually substitutes defamation. So whether those comments
As
are
John said,
actually
Mr. Tully,
defamation.
being a law student, said denied any wrongdoing and said if it went to court he would rely on a defence of truth and honest opinion. So it'd be very interesting. Anyway,
Yes.
viewers, we've got to go to a sponsors break. Stay tuned after the break. We're going to give you an update on the Workcover self-Australian legislation. Viewers, welcome back to the show. As I said before the break, we're going to be talking about the Workcover system in South Australia. Now, Irena, there's been some significant changes, and in particular, they've reintroduced common law But before we go to that, the system's based about return to work. So let's say, for argument's sake, you're injured. As a worker, what should you do?
As a worker, when you're injured, you should obviously notify your employer as soon as possible and get the appropriate treatment as soon as you can, because you don't really know how serious your injuries are until obviously you get them checked out. So that's obviously quite important to put your employer on notice so they can make the right changes to facilitate your return to work if you're able to do that.
So the important thing, Irena, is to ensure that you lodge a claim. That's the key word.
That's correct. Regardless of how significant your injury is, it's very important to lodge a claim, puts your employer on notice and protects your rights.
John, you're very familiar with the Victorian system. You're an accredited specialist here. When it comes to weekly payments and medical expenses, it seems like the systems are reasonably similar. Is that a fair assessment?
Yes, Tony. Again, once a claim is lodged and the worker actually writes out the claim form, and again, viewers, you have to make sure that what you write in the claim form is actually correct and accurate. And if it was the fault of someone else or the machinery, you want to make that clear in the claim form. Otherwise, years down the track, we've seen, haven't we, Tony? All coming back to what was written in that first initial claim form. So that's very important. Now, workers are entitled to weekly payments of compensation. In Victoria, it goes for 130 weeks until the no work capacity test kicks in. In South Australia, it only goes for 2 years, Tony.
And after the second year, you need a serious injury. We'll get to that afterwards.
Exactly.
Irena, John mentioned something really, really important, and a lot of workers take it for granted. Putting down exactly what happened and making sure that you put it in a light where if someone else is at fault, you can substantiate that in due course.
That's right, Tony. I don't think we can really stress the importance of this enough, because we've had a lot of cases that we've had to deal with in which people put details such as the date of injury that's in many occasions not correct, and that's something then we have to fight in court, and it's a very particular thing we can solve the problem by you getting it right from the start. Also, the type of injuries that you've sustained, you might think it's just your neck that's been affected, but obviously get checked out by a doctor and see whether that injury is perhaps something more than just that area.
So the important thing is make sure you document all your injuries.
That's right, Tony.
Yeah, and also specify in a broad enough sense so that you can cover the injuries, how they occurred.
Exactly. The circumstances of the injury is vital, Tony. Especially if it's someone else's fault.
Okay, just on the issue of fault, if someone's got a nasty injury and it's serious, that is under the South Australian system, what's a serious injury now, John?
In South Australia, Tony, the injured worker is assessed by an independent assessor, and under the 5th edition of the guides, and if you have 30% impairment or more, you're deemed to have a serious injury.
Gee, it's a pretty harsh test, isn't it, Irena?
It's a very harsh test, particularly when comparing it to Victoria. In Victoria, we're quite lucky to also have the narrative test, which John can take us through, but threshold in South Australia is quite high, and it just means that the amount of people that can be entitled to common law is obviously now quite limited.
John, the 30% test under the AMA Guides 5, that is very, very high, isn't it?
Tony, instead of having, let's say, 20 people entitled to a serious injury common law damages claim, you'd only have about 2, maybe 3.
If you're lucky, you get 2 or 3.
Exactly.
I mean, under the Victorian system, we rely on the narrative, which is what?
In Victoria, you have the 30% impairment under the 4th edition guide of the guides, but then you also have, in addition, or as an alternative, the narrative test, as in, if you show that you have suffered serious consequences as a result of the work injury, then you are entitled either by the court or the County Court of Victoria or the Victorian Workcover Authority to have a serious injury certificate.
Okay. Irena, serious consequences, what are the things we look at?
Common things that are consequences, particularly say for people that are mothers, things that they aren't able to do anymore, things like housework, things like looking after their children, things such as driving, how their injury affects their sleeping pattern, things like that. So it's not just about how it affects your ability to return to work. It affects it's how your injury affects your ability to live your everyday life.
Physical impairment, Tony.
Yep.
The way you walk, the damage to your spine, psychological impairment, as in that you can have a psychological claim, but you have to have severe behavioural disturbance. Okay. It's a very high test.
High test.
But again, the medication that you're on, sleep disturbance.
Yeah, of course. And I guess the easiest way to prove that you've got a serious injury is if it impacts on your capacity to work.
Exactly.
Isn't that right?
If you can't work as a result of your work injury, I always actually say, Tony, that why don't you have a serious injury?
Well, more often than not, if you cannot do your pre-injury duties,
exactly,
that does set aside a serious injury test.
It's a really big indicator.
Yep. Irena, if someone's injured working for a third party that's not an employer, let's say a host employer, you can get around this 30% test. You can just sue. And there's quite a few of those these days, isn't there?
It's the most sort of common situation where that occurs is where we do have host employers. For example, if you're employed by an agency and then you go and perform your duties for another employer. So it's very common these days and something that we see a lot. And
John, the host employer, they get the job for you, is that correct?
Exactly. You have situations, Tony, where the employee, the worker, is employed by an employment agency, and then they subcontract the worker out to the host employer, which could be a work site. Now, there's still duties and responsibilities by both sets of employers, and unfortunately, a worker, once injured, still has to go through the gateway.
Yeah, but if there's a third party, you can get around it in South Australia. It's always been like that. Where you can get around it, you just sue a third party.
In South Australia, yes, that's different. In Victoria, on the other hand, unfortunately, no. No.
Viewers, we've got to go to a sponsors break. Stay tuned after the break. We'll continue this discussion about the amendments to the South Australian law. Viewers, welcome back to the show. We're talking about the South Australian legislation and update in South Australian law. John, the biggest thing that's occurred in South Australia is the reintroduction of common law.
Yes.
Tell us a bit more the significance of that.
With the the election of the new government in South Australia, Tony, one of their platforms was the introduction of common law. And what's occurred is anyone injured at work in South Australia post 1st of July 2015 is now entitled to common law benefits, common law entitlements. Now, common law entitlements includes compensation for pain and suffering and economic loss for injuries that were not your fault, could be the fault of the employer or any other party, as a result whereby you have sustained the serious injury of that 30% threshold, Tony.
And the fifth edition of the AMA guides, Irena, is supposed to be a bit more sympathetic because it looks at movement, whereas the fourth edition doesn't. So 30% is hard to get to, but
very hard.
I think the fifth edition does sort of assist a little bit.
Yeah, I think it'll assist workers in reaching that threshold, or at least getting a bit closer to that 30%, because it does take into account things such as movement. However, I think viewers should really understand that 30% is a high threshold, and that unfortunately workers in South Australia will have difficulty getting to that point unless they've sustained some pretty significant injuries.
And if that occurs, the other thing you've got to look at too, John, is you've got to make a decision. Do you leave them on payments, or do you try and settle up the claim? Because to get the 30%, they must be pretty substantially damaged.
Oh yes, it's a serious. Well, clearly, if you've received 30% impairment, well, you are suffering physically and psychologically. Unfortunately, Tony, there'll be a lot of workers that fall within the 5% to 29%.
And if that occurs, what happens there, Irena? 5 to 29%, there's a lump sum benefit available, isn't there?
That's right. There's a lump sum benefit available for economic loss. However, they're not entitled to those common law entitlements.
And they're not big, are they, John?
No, it'll be for economic loss and for pain and suffering as a lump sum benefit for anyone up to 29% impairment. Now, at 5% impairment, Tony, it's around $12,000, $13,000.
It's not much. No, it's not much considering.
Yeah,
you know.
It's not much. And at 29%, it's most likely around the $80,000 mark.
Okay.
Which is, look, there's a bit of money there, but it's nowhere near what you're going to get if you have 30% or more.
No, that's obviously... and also, if you compare this system here to the Victorian public liability system, where if you've got more than 5%, you get pain and suffering, and the average settlement in public liability has got to be at least 60 to 80,000 for pain and suffering, don't you think, John?
Exactly.
Yeah.
Exactly.
Irena, with someone that's, let's say, not 30%,
Yep.
their benefits cut off after 2 years.
That's right. They've got an income protection for 2 years, and their medical expenses are only covered for 3 years. So it's quite limited. And in the event that someone's 28% impaired, it sort of rings alarm bells to think that they've got sustained such a high impairment, but are only entitled to a capped benefit.
So Tony,
The system's a bit of a sham.
It's great that the government has reintroduced common law in South Australia for workers because, as we know, for years
it looks like lip service to me.
But the problem is it's a very limited introduction, which really will only assist a few workers, Tony, in the end.
Yeah, and the thing I see is this: someone that's going to get 30% under these guides, which is very, very high,
Yes.
might not want to get a common law settlement.
Exactly.
They might want to just stay on payments because what if the settlement's not big enough to get you through life?
Exactly.
That's right.
Exactly.
At least you've got the security of getting benefits into the future.
But
But that creates its own problems too, doesn't it?
That's why viewers and injured workers, you need to seek legal advice. At Tony Carbone, we understand what's happened to you and we want to make sure that you're taken care of.
Irena, one of the things important when you're dealing with these injuries, because the test is so strict, you need to make sure you encapsulate all the injuries. What does that mean?
That's right. So, for example, if you sustained an injury to, say, your right elbow, you have to take into consideration how that affects, say, your whole right arm.
And let's say you might have a neck injury, it might involve your shoulder.
Exactly.
There might be, I don't know, other things that flow from that. The
Exactly.
neck might give you headaches.
Well, the neck, it's spinal damage, Tony, and it could be going down your spine per se. So,
Yes.
So that's where, again, injured workers, you need to clearly explain to your general practitioner, your doctor, how you were injured and where you are suffering.
And make sure you cover all injuries because you can't go back. If you miss them, that's it. Look, it seems that the philosophy behind this whole amendment to the legislation is to get people back to work, Irena.
That's right. It is called the Return to Work Act, and they're trying to facilitate injured workers to return to the workforce, which is completely understandable. However, if the injuries are significant, I'm not sure about the chances of that.
John, I don't want to sound cynical, but if you've got injuries between 5 and 29%,
Yes.
and getting higher into the 20s, you'd think there are people that would be struggling to do any work.
Oh, yes. Oh, yes.
So you're going to have a workforce that's almost totally inefficient and unproductive.
Exactly. Realistically, anyone with an impairment over 15 or 20%, Tony, they are severely damaged.
Don't have a lot of problems.
Physically and psychologically. And to say that that you have to go back to work with those issues and the medication that the worker is required to take, it's virtually impossible, Tony.
It is. Irena, I'm somewhat, I don't know, this whole system here, it's almost designed to push the worker onto the federal system of Centrelink benefits.
Exactly.
Which is quite disappointing because, we are so fortunate in Victoria to have such such a good system that's very favourable to workers, and this one just doesn't seem to have that effect.
No. Well, the Victorian system is reasonably tough in its own respects, isn't it?
Very tough.
Yeah.
To prove that you have a serious injury, it's very tough in Victoria. However, if a worker does illustrate and show what the physical and psychological consequences of the injury are upon them, well then, a court may be satisfied. The Victorian Workcover Authority may be satisfied. And that's where a worker may receive a lump sum payout and they're off the system.
That's it. And then they can try and get another job in the future.
Exactly. Whereas in South Australia, they're forcing people to stay on the system, and hence why, the South Australian scheme has been in deficit for the last 10 years, Tony.
Exactly. Well, viewers, we come to the end of the show. Irena, thanks for coming on board.
Thanks
Great
for
first
having me,
appearance.
Tony. Thank you.
Get you back in the future. John, always a pleasure to get you on board.
Thank you, Tony. Thank you, viewers.
Viewers, thanks for watching. Stay tuned for future episodes. Go to our past episodes on YouTube. Look at our social media platforms, and always remember to stay safe.